Appeal court reverses on return to Kuwait for asylum-seeking mother and kids. An appeal of a case we recently reported on only a few weeks ago. The Ontario Court of Appeal reversed a judge's prior order that 3 children be returned to Kuwait, despite allegations that their father, who lived in that country, had physically and sexually abused their mother. The mother of 3 children removed them from Kuwait and brought them to Canada without the father's consent. This was about 2 months after what she said was a physical attack by the father in front of the children. When she arrived in Canada, she claimed refugee status for herself and the children, based on allegations that the father had been abusive on multiple occasions, and that Kuwaiti law was inadequate to offer the needed protection for her. In asking the Ontario court to exercise its jurisdiction to decide her custody-related claims in connection with the children, the mother claimed that the governing 2-part legal tests had been met. Namely, number 1, the children were physically present in Ontario, and number 2, on the evidence they would suffer serious harm if removed from this province. The mother offered uncontroverted expert evidence in support of the second aspect. Meanwhile, the father, who strenuously denied attacking the mother or being abusive, countered by applying for an order to have the children returned to Kuwait. The application judge found against the mother, having not been satisfied on a balance of probabilities, that there was risk of serious harm to the children. Despite the pending refugee claim, the judge ordered the children to be returned to Kuwait immediately. The mother brought an appeal, which incidentally was heard by video conference and was supported by several intervenors, including the Office of the Children's Lawyer, the United Nations High Commissioner for Refugees, and Amnesty International Canada. In her view, the application judge had wrongly discounted certain evidence. The Court of Appeal agreed. It concluded that the children's uncontradicted and independent testimony, as provided through 3 separate Office of the Children's Lawyer experts, clearly established a risk of serious harm to them if they returned to Kuwait. The application judge had wrongly discounted that evidence on the apparent basis that it could not be given sufficient weight, or that it was the product of the mother's inappropriate influence. The judge also offered no explanation for rejecting the uncontested evidence of numerous expert witnesses. The appeal court ruled this was an error. On a balance of probabilities, there was an established risk of serious harm to the children, so the application judge should have exercised the jurisdiction to make a custody order on the spot. Moreover, the children were entitled to protection during the process of seeking asylum. They should not have been ordered returned to Kuwait. Instead, the application judge could have exercised various legal options, such as adjourning the present matter until the refugee hearing could be held. In the end, the Court of Appeal overturned the prior ruling and ordered that custody and access hearing was to proceed in the Ontario Superior Court of Justice as soon as possible. Thank our listeners and our watchers on YouTube. You can subscribe to our upcoming videos. Please like and share and comment on these videos and our podcasts. We'll endeavor to answer all your questions at the end of each week. Until next time, I'm Russell Alexander.